Let's get back to it.
Concerns, Mr. Lamar, Rich Homie Kwan, and neither side really should be able to say, it seems that the defense wants to bar the state from being able to say, the defense didn't call this witness at trial, which obviously they concede they have no right to do and say they have no intention of doing, and they would not be permitted to do such. But at the kind of flip side of the same coin, the defense seems to maybe be suggesting that they would like to to present that the state could have but did not call that witness. And I would not permit that either, because we're clearly nowhere near, unfortunately, the end of the state's case. And obviously, Mr. Lamar has now passed, and so we don't know whether they would have called that witness or not. So I wouldn't permit the defense to make that kind of a presentation either. So I trust that everybody understands what they would not be permitted to do. And then we have, yes, sir.
Speak to that for a moment?
Yeah.
Thank you. Good day, Your Honor, and good day, everyone.
Good morning.
So I understand your ruling, obviously, abides by it, but what I'd like the record then to show, if you don't find this to be changing, the state sent us lists of witnesses on a short list that they were going to call Mr. Lamar, who's a performer known as Rich Homie Kwan. This was well before September 5, 2024, when he, God forbid, passed unexpectedly. So to me, and the state has put in evidence over objection that starting in the fall of 2014, Mr. Lamar and Jeffrey Williams don't get along, and Mr. Lamar is with Mr. Donovan Thomas, who doesn't get along with Jeffrey Williams. And it's all, to me, it's all made up. It's not supported. Obviously, the jury can make that determination. But I think that it is important that the state, in writing, put the predecessor court, as well as the Mr. Williams et al., on notice that they were going to call Mr. Lamar. They filed their service of a subpoena, and they don't call him to support this, supposed beef. And I can't do anything about his prior statements now because it would be frivolous under 24-8-807, which is rarely used, it's frowned upon, and it has to have the same guarantees as a dying declaration or something. It's not like that. He gave interviews throughout all the years talking about his close relationship with Jeffrey Williams. And if you let that in, that's great with me. But I'm assuming you're not going to let it in, so I wasn't going to try to get it in because I don't think that that's a dying declaration type of statement. So I'm stuck. So I would like the jurors to know that unfortunately he passed, and the state stated that they would call him as a witness and subpoenaed him. And if the state has reasons that they didn't call him, that's fine. I understand I'm opening a door, but that's why I put it in writing. That's my motion.
All right. Well, I mean, if the state's case were over with, then that would be a different argument. But it is not as though the state's witness list has stayed in anything like any semblance of order during this trial. So, I mean, I don't think that if you can get a concession out of the state that they weren't going to call him even if he stayed alive, that would also be different. But I don't think that we've got that situation.
I understand the ruling.
All right.
Thank you, Your Honor.
Okay, and then we have this issue of the state wanting the court to reconsider its ruling striking whatever day that was, that one day of the detective's testimony and the defense response. And I believe, and Mr. Armstrong, I see you standing because you might want to argue, but I think that the waiver argument that is presented in the defense response is meritorious. I think that the arguments that the state made after that they were waived because they certainly were not made at the point in time when I could have done something about it. But in addition, the state last week ended up calling a different detective and investigator, Detective Underwood, who's on the stand essentially right now in the midst of her testimony and seems to be covering the same things that the other investigator was covering anyway. So it doesn't even seem, I mean, it seems like this whole issue is moot.
Yeah, you heard, Your Honor?
You may be.
May it please the court, Kevin Armstrong for the state. First of all, the contemporaneous objection rule, which was cited by the defense, which is the waiver argument that Your Honor referred to, is one about preserving an issue for appellate review. It is not about a court who can reconsider their rulings during trial. One of the issues that is here is that the court precluded the state from calling that individual back to testify about other things. And that's one of the things that the state filed the motion for reconsideration to avoid. And so the state is asking that for other issues and for whatever issues that have not already been addressed, the state be allowed to recall Detective Dennis to testify about other matters that were not the offending statement, which the court appropriately excluded from evidence. And one of the things the defense brought up in their response was confrontation. I want to make it absolutely clear that there was no intention in the motion for reconsideration to have state's evidence in that they didn't get the right to confront, and so that was not part of the issue. But the issue isn't only the testimony that was struck from that day, it was his future testimony, precluding him from testifying in the future. And while there are other means to get in some of the testimony, I don't believe that is all the testimony that the prosecution team intends to get in through Detective Dennis. And so essentially it's an ongoing order of the court that we would be asking the court to authorize the state to present that witness to testify further.
So tell me what it is that this other investigator or detective is not going to be testifying to, because she was qualified to be able to testify to the meaning or her opinion as to the meaning of particular lyrics. So what is it that only this other witness, Dennis, could testify to?
I'm going to turn that over to the facts prosecutor.
All right.
Thank you, Your Honor. Detective Dennis testified to a statement regarding Defendant Kendrick, in which Investigator Underwood was not present for that interview, and so he testified to that. He also testified further regarding the Quindarius Zachary interview, in which Investigator Underwood was not privy to that interview as well. Additionally, Your Honor, he was able to introduce several additional exhibits to include the Magic City video that will not be able to come in through Investigator Underwood. And I believe those are the three primary things that Investigator Dennis was able to testify to previously that was struck that Investigator Underwood would not be able to introduce during her testimony. And course indulgence for one moment.
All right. Thank you.
Thank you, Your Honor.
Okay. So, Mr. Steele, I guess you sort of led the charge on this, if I'm not mistaken. What do you say to the state's position that the court's decision to strike and prevent further testimony of this witness isn't a remedy that is permitted to the court by statute or the Constitution, and understanding that if this were reconsidered, the state would be, I mean, the defense would be permitted to cross-examine?
So I believe that you have the authority, jurisdiction, and power to prevent a witness from testifying when that witness shows that they are not capable of providing a fair trial and intentionally, and that's my word, but it was clear to me sitting there that when Ms. Hilton asked retired Detective Dennis, tell us about this photograph that has Mr. Kendrick standing on top of a car, his initial lead into that answer is, well, Mr. Kendrick just got out of prison. And, you know, that affects Jeffrey Williams. Mr. Kendrick, as the court may have heard, is signed to Mr. Williams' record label. Mr. Kendrick, as you will learn, is at Mr. Williams' home on May 9th, 2022, when Mr. Williams and Mr. Kendrick are arrested. And it is just not that simple to unwind that instruction. It was an intentional, obvious infliction to denigrate this trial and prejudice Mr. Williams, Mr. Kendrick, and all. So you then have to do something about it. And what you asked to do is declare a mistrial. And you said, I'm not doing that, but there will be a sanction. So what are you going to do? So to me, that was the second time. The first time the court, I'm not saying it's not accurate.
So obviously, considering that I'm the one that imposed the sanction, I think it was an appropriate sanction. Address the state's argument that a trial court doesn't actually have the authority to impose that sanction. I
think that's wrong, based upon, let me give you, and I put it in my response, but Illinois versus Allen, 397 U.S. 337, it's 1970. What happened there, and the U.S. Supreme Court took down, that was an accused right to be present at a trial, constitutional right. And there's a dissent in it saying the accused, no matter what their conduct is, they could be gagged and bound. They have to be in the courtroom and watching the proceedings. Otherwise, it's a constitutional violation. But the majority said, this is ridiculous. Courts have to have the power to ensure that the trial is, and I'm quoting, conducted with dignity, order, and decorum. They are the hallmarks of a court proceeding. And then I found a case, I just found it amazingly similar. California versus Navarrete, Navarrete. Your Honor, it's 181 California Appeal 4th, 828, 2010 case. And in that case, a detective is testifying, and there was a suppression motion granted. There was no Miranda rights given to Mr. Navarrete. And the detective testifies on the witness stand and said, well, the reason I didn't follow up on this DNA swabs is based upon the client's or Mr. Navarrete's statement. The judge did exactly what you did. The judge called the prosecutor, well, a little different, called the prosecutor and defense counsel in chambers and yelled at the prosecutor and said, you know, I'm demanding, what are you doing? And the prosecutor said, I didn't know that that would happen. Just like here, I'm not saying that it was Miss Hilton eliciting that on purpose. I had no information that she would ever do that. But the judge said, well, this detective knows better. I find the detective is trying to harm this trial. The detective is barred. His testimony is struck, the direct is gone, and he can no longer testify. And the state did exactly what happened here. The state in California, the prosecution, the people, they called the next witness. To me, it's on all fours. The appellate court, Mr. Navarrete is, God forbid, convicted, and the appellate court then reversed and said, that remedy did not go far enough. That had to be a mistrial, that intentional conduct. And here, I'm asking the court, I believe that you have total authority. There is no way that anyone will convince me, I'm not the one who needs to be convinced, that Detective Dennis did not realize. It came out of nowhere. What difference does it make that Mr. Kendrick was released from prison 5 weeks earlier? What difference does it make? He did that to bring out to the jury that Mr. Kendrick was in prison for, and I'm telling you, it's a federal offense, a gun charge. There was no basis. So to me, to say you don't have the authority to do that, I believe you have every authority. If a witness comes in here and starts cursing, I'm using an example, I would assume, you are going to say, you know, this is just not decorum. You can't curse. The witness curses again. You're going to do something. You're done testifying. Courts have that power. So I believe that the state's argument that you have no power to control the proceedings is not backed up by the U.S. Supreme Court.
All right, thank you.
May I respond?
You may.
There was a defense attorney who raised their hand.
Good morning.
Good morning, Your Honor. I want to be very brief because I don't think what I'm going to add is truly what Your Honor's looking for, but. Jay Apt, Your Honor, good morning, on behalf of Mr. Kendrick, and I'll try to be extremely brief. Your Honor decided this issue in lieu of granting a mistrial, and one of the things I want to remind the court, really I'm just here to remind the court, is one of the reasons for this sanction, Your Honor, is because of, and I'm not pointing fingers at any particular district attorney, but the state's repeated unpreparedness, their repeated discovery abuses, and so this is a compound issue. And I think my perception is that the court finally had to say, okay, we're not granting a mistrial, but we got to do something. And if you now go back on that decision and reverse your own decision, you are essentially creating an incentive for the state to continue these, I'll call them mishaps, whether they're negligent or intentional. And I think the court has sent a clear and convincing message to the state that they need to be buttoned up, more buttoned up than they have been. And so I would ask the court, certainly the court has the authority, and Mr. Steele has done a very good job of explaining that, but I would ask the court to uphold its own decision to send that loud and clear message. Thank you, Your Honor.
Thank you. Mr. Armstrong.
Yes, Your Honor. I would agree with Mr. Apt to the point that I would like the court to uphold the determination that the court made, which was that it was not an intentional, willful act, as Mr. Steele has argued. I want to address both of the two cases that he referred to, Illinois versus Allen. One of the issue in Illinois versus Allen was a defendant who refused to act with decorum and was excluded from the courtroom, but was permitted to come into the courtroom if he was going to behave correctly. And so it went specifically to the offensive behavior for as long as the offensive behavior went on. We are asking the court the court appropriately struck the testimony that was at issue. We are asking the court to go further with other testimony that was not the offending testimony. Now, People versus Navarrete is the only case the defense has cited to suggest that this specific remedy was permitted. That is a nationwide search in People versus Navarrete, Navarrete, is the only one that they were able to cite, and that is materially different in a number of ways. Number one, the facts are wildly different. The officer in the case was mad at the judge for excluding a statement that the officer had obtained, and actually had told people that when the prosecutor found out, told the judge after the fact, when they found out, that the officer had basically said he was going to do this because he was mad at the judge and would show the judge what for. That is not anything what happened here. And the reason that the appellate court in California decided that a mistrial was necessary in that circumstance was because of the specific evidence in that case, which is basically three things. You had a witness testifying the defendant had committed lewd acts against them. You had somebody testify they took about, I think it was a dozen or more swabs relevant to that. And then you had the officer testify, oh, I didn't think it was relevant to get the swabs because of the statement the defendant made that I can't talk about. The officer specifically said that because it would prejudice the defendant. And those are the circumstances in which it would, in fact, be incapable for a court to take that away. I would note before I go on to my main point about People versus Navarrete is that the California appellate court stated, we note that a trial court can almost always cure the prejudice of an improperly volunteered statement by granting a motion to strike and charging the jury with an appropriate curative instruction. This court did exactly that. It was just the exact facts, how thin the state's case was on that issue, on basically the entire case. And the reason for it was why they decided a mistrial was necessary on appeal. More importantly, this is the case that they cite that says the remedy of preventing Detective Dennis from testifying further. This is the case that they use for that proposition. At no point in this decision does the appellate court address the legality of that. They simply don't do it. It is not addressed whether that was a legal remedy to occur. It's not something that stands for the proposition that the defense is citing it for, which is that the remedy to prevent Detective Dennis from testifying further is appropriate. And so they have not pointed to any statutory or constitutional authority, and under Rule 402, the exclusion of evidence can't exist outside of that in the state of Georgia. Now, I'm sure, let me just strike that. So we were just asking that the detective be able to testify further in the case when the prosecution team determines that he is the person who's best able to testify to facts that are relevant for the jury's consideration.
All right, thank you. So I don't think that the facts in the California case are really that different than the facts here. Frankly, I think that an argument could very plausibly be made that the detective in this case was upset with somebody about his qualifications having been challenged and had made a decision that he was going to show somebody what he thought about that. I don't know that that's what happened, but I do think, like I said before, that the detective absolutely knew better than to have said what he said and did it anyway. And I have given consideration to everything that has been presented, but I am not going to change my decision about this. All right. I think that the next thing that we had to do was sort out the remainder of what we're calling the Ryan